Okay. All right. Again, thank you for joining us today. Welcome to today's CLE presentation by C. Michael Ireland Jr. and Sarah Camille Casas on trial mistakes to help your attorney avoid a top 10 list. This will be an interactive session, so feel free to post your comments and questions in the chat room and we will monitor those. And then towards the end of the CLE, a passcode will be issued. If you would like to receive a certificate for this presentation, please send a request via email to myself, Elena Taylor. I am the medical/PI and real estate section chair for Dallas Area Paralegal Association. I'm joined by the DAPA administrator, by Veronica Redmond as well, who will help us facilitate this presentation. But if you would like to receive credit for this presentation, please send a request via email to myself, etaylor@foxrothschild.com, along with the passcode, and a CLE form will be sent to you. Again, thank you for joining us. I'd like to introduce the speakers today. I'll start first with Mr. Ireland. This is C. Michael Ireland Jr. He is an associate attorney in San Antonio, Texas, and his areas of practice include family law, probate, and real estate litigation. Mr. Ireland is board certified in family law and received his law degree from St. Mary's University School of Law in 2012. He is also a member of the San Antonio Family Law Bar Association and is the current vice president. The Family Law Bar Association of San Antonio, the San Antonio Bar Association, and the Texas Family Law Foundation, the Texas Academy of Family Law Specialists, and the Texas State Bar Family Law Section. Mr. Ireland manages a robust family law docket and enjoys being in the courtroom. He is also a well-regarded family attorney who takes pride in providing hands-on, creative, and thorough representation of his clients with an eye for detail. Also joining us is Sarah Camille Casas. She is an associate attorney at Higdon, Hardy, and Zuflack LLP in San Antonio, Texas, whose area of practice includes family law. Ms. Casas graduated summa cum laude from Texas A&M University College Station in 2018 and received her JD from Tulane University School of Law in New Orleans, Louisiana in 2022, where she earned a distinction for being in the top 10% of her trial advocacy course. Ms. Casas is a member of the San Antonio Young Lawyers Association, a member of the Texas State Bar Family Law Section, and a member and a committee co-chair for the Collaborative Divorce San Antonio. While in lawsuit, Ms. Casas clerked at Higdon, Hardy, and Zuflack LLP and had the opportunity to co-author a published professional legal article, At Your Service, All the Creative Ways to Get Someone to the Courthouse. Please join me in welcoming Ms. Casas and Mr. Ireland as our presenters today.
Yay, congratulations. Happy to have you guys.
Yes, okay, we're happy to be here. I believe we're right at noon, so good afternoon, everybody. I'm going to go ahead and share my screen. We've prepared a PowerPoint about our paper. So let's see. Can everyone see this?
Yes.
Okay, great. So this paper was authored by Mr. Ireland, and it was published and shared in the materials that were presented at the Advanced Family Law Seminar that's held every year in San Antonio, Texas. It's one of the biggest family law conferences of its kind in the country and the biggest in the state. And it was presented there, and it was originally trial mistakes to avoid a top 10 list. And we have adapted from that paper a top 10 list of trial mistakes to help your attorney avoid. So without further ado, I guess I'll get started. And we'll go through each slide. It's mistake 1, mistake 2, mistake 3. And if I would love for you guys to ask questions, just wait till the end of that slide before I move on to the next one to ask any questions, okay? All right, so like being a lawyer, being a paralegal requires constant attention, constant contemplation, constant education, preparation, and continued growth. Regarding constant attention, I'm not embarrassed to say that I have reviewed things multiple times before and caught mistakes only after I filed them. After I've said this is ready to file and I've handed it off to a paralegal or a legal assistant in our office, And sometimes when I get to court and I'm sitting there and I'm reviewing my pleading, waiting for the judge to call my case, and I realize that, oops, there is a typo right there, and I've called my client, who is a woman, a man. And that's never good. And so constant attention is critical. And whenever I was in law school, when I took legal research and writing, one of the best pieces of advice I ever got was, whenever you're reviewing things, it's always best to review them hard copy paper and read them out loud. You're going to sound crazy to everyone else in the office, but whenever you read things out loud, you catch a lot more mistakes than you do reading them on your screen. Constant contemplation is something that kind of requires a paradigm shift, is what one of the partners told me recently. This isn't a 9-to-5 job, right? Especially if you work in family law. You have clients calling you late at night, early in the morning. This job is 24 hours a day, 7 days a week, and it does require you to constantly contemplate everything that you're doing. Becoming indispensable at your job requires that you're constantly thinking about what you're doing, and not just passive thinking, right? Like active thinking. You're being conscientious. You know that your lawyer's bar card is on the line. And whenever you ride for the brand, like my dad says, it really, really, really will make you an indispensable part of your attorney's practice. Being mindful about how you can prevent mistakes before they happen, and always being mindful of what you're currently working on, and always thinking about ways to get better at those processes. Constant education, you're doing it right now. Congratulations. CLEs like this one, they're great. You can do them on your lunch hour like you guys are doing right now. Advanced Family Law, where this presentation was originally given to attorneys, is the best. If your attorney's going, I strongly encourage you to go. There are a couple of paralegals from our office that go every year, and those paralegals know more about family law than I probably ever will. It's great. It's the best and brightest minds in the field, like Mr. Ireland here. You can always ask questions. The appendixes that are in those papers that get filed that get included in those materials for the CLEs, those are really helpful for you to keep in your internal filing system at work. I've always wanted to read for fun, but I didn't know where to start, fiction, nonfiction, drama. But I love my job, and I'm not saying that because I'm not just saying that because there are some members of like our support staff online today, I believe, but I do really love my job. And so I started reading CLE papers for fun, to get better at my job, to learn, and that's always a really good way to do that. There's a multitude of resources online that provide free papers and free CLE articles, and I encourage you to look those up. The Texas Family Law section of the State Bar prints great stuff too, like the Predicates Manual, the Texas Family Law Lawyer Toolkit, which I actually was on my desk and I just had my intern put it up for me. Those are great tools as well, just to look at, to get better at your job, and this is what, I think this is what last year's looks like, and you can get a copy of it. Your boss probably has one if you practice family law. Preparation is our fourth key principle to being a great paralegal. I tell my clients of mine and supervising attorneys all the time, I may not win, but I will not be out prepared. There are lots of things we can't control. We can't control being the smartest person in the room, but we can control being the most prepared. Preparation prevents so many mistakes. And the number one is failure to prepare. We will get there. So number one trauma mistake to avoid. My dad always told me growing up, you know what, things may not go our way, but it won't be for lack of trying. So don't ever let it be for lack of trying. Continued growth is kind of the last pillar in things that you should always keep in mind, trying to be the best paralegal you can be. Don't ever stop trying to get better at your job. There's always ways to improve. And the best way to continue to improve is to acknowledge, look, there are things that I could probably be doing better. And it's okay to admit that. It doesn't mean that you're a bad paralegal. It means that you're a great paralegal and that you're the best because you're willing to acknowledge that you can be better in certain areas and you're doing what you need to do to improve in that. Okay, so without further ado, we'll get to mistake number one, failure to prepare. The best and easiest way to help your attorney prevent this mistake from happening is go ahead and assist your attorney in reviewing pleadings, reviewing direct questions, and making sure that you're not asking any leading questions on direct. Reviewing pleadings is important because you need to make sure that your requested relief is actually in there. Reviewing opposing counsel's pleadings is also important to make sure that their requested relief is actually in there. The court can't award any relief or any request that's not pled for, right? So it's really important to make sure that your attorney, you know, at lunch when y'all were going over your case list didn't, you know, make an offhanded comment, oh, we need to make sure that, you know, we've pled this in our motion for enforcement. And you said, oh, okay, yeah, and you failed to write it down. And then you didn't go make sure that that was in there. Always make sure that, you know, you review your pleadings to make sure that, and OAs as well, to make sure that everything is where it needs to be. An easy way to do this to help your attorney is to draft a summary of requested relief. That will, most judges are requiring it nowadays. Some, it's kind of an unwritten rule. You should always come prepared. And in any event, it's great because it gives lots of times opposing counsel, if it's not required in your jurisdiction, will forget or neglect to print one and bring it to court. And now, guess what? The judge only has your requested relief in front of them, and it makes it really easy for them to go down there and grant the relief that you're requesting when your attorney is out there putting on evidence, eliciting testimony to get you to that requested relief. Direct questions. I'm not sure to what extent you guys help draft those questions, but lots of times I am just pouring like a stream of consciousness into a document, and I'll show it to a paralegal who is a really, really, really talented trial support, like litigation support paralegal in our firm. And she'll say, okay, well, this, you're going to catch an objection. This is a leading question. I would ask it this way. So obviously that leads us into my next point, that leading questions are obviously ones that require a yes or no answer. Direct questions require an open-ended answer, necessitate an open-ended answer. And so just having a familiarity with those two and when you're permitted to ask each one can kind of help your attorney not draw a leading objection. Michael, do you have anything to add before we take questions?
No, I think, and by the way, thank you guys for having us here today. I thought I was coming to a celebration of the beginning of Cowboys camp, but obviously that's not why we're here. You know, Sarah said a lot of really good things. I think I rely on my paralegal quite a bit to, you know, help me get clients in to prepare them for hearings or trial. You know, I don't know how many of you do family law, but I'm always shocked at the amount of family attorneys who show up to hearings and trial and are not prepared. And if they're not prepared, their clients aren't prepared. And so I think that might be one of the most important things we do, because most of these folks have never been in a situation where they've had to testify, whether it's at a deposition or in court. So, you know, preparation cannot be emphasized enough. I have a bad habit of reviewing or drafting pleadings or reviewing pleadings and missing typos or having weird sentences. And so, you know, it's always important to have someone else check your work. Whether you do the drafting or your lawyer does the drafting, 2 sets of eyes are better than 1. So that's all I've got right now.
Great. Does anybody have any questions yet? Okay, we'll keep moving. Michael kind of touched on this a second ago, but the second mistake to help your attorney avoid is failure to prep clients and witnesses. Now, this is something that I really, really, really do rely on interns, law clerks, and support staff to help me do. Lots of times I do not have time to sit someone down and run a mock trial with them. Different attorneys prioritize running mock trials. There are a couple of partners in our office that do them, a couple that don't. I do kind of a hybrid approach. Rather than just sending some questions I drafted and saying, hey, review these, let me know if you ask questions. I may add some, I may change some. I ask them to come down to the office. We sit down in a conference room, and I'll usually have at least one paralegal or one law clerk or intern in there with me. And I go over not just my questions, but the questions I think that the other side is probably going to ask. And we go through them. I give them a disclaimer. Look, I'm going to sound really mean to you for a second, but it's not me asking these questions. This is opposing counsel asking you questions, and it's going to be so much worse tomorrow. Because like Michael said, a lot of these people, they've never testified before. They've never had to raise their right hand and swear to tell the truth and nothing but the truth, so help them God. They've never been in a courtroom before a lot of times, and it's really scary. And so, I mean, if you aren't going to haul your client down to the courthouse, the next best thing is for you to sit down in the courtroom, in the conference room with them, or in your attorney's office, and help them prep the client. And this is something that you can help do because you know the case, right? You helped draft some of those questions that we talked about earlier, and your attorney might not have the time to sit them down and go over a 1 hour direct and cross for this temp orders hearing, or a 2 hour, direct and cross for a final trial. So that's something that you can really help them assist with. I like to do at least 2 or 3 cold turkey dry run throughs, and then one more when we get there before court starts. That's just me. I like to get them there early and review with them. And the best part about you guys assisting your attorney is that the client might say something and you might think to yourself, oh, you know what? They're going to say that on the stand. That's not going to sound real good. How about we ask them this different series of questions instead of just that one question? We'll get better testimony out, and it'll sound a lot better, and it'll help our client out, and it'll help our case, right? So reviewing direct questions, super important. Discussing goals with your client is also super important. You and your client have got to be on the same page. Sometimes I have to remind clients, this isn't my life. I won't have to live with this. I won't have to abide by these orders. I won't have to deal with this man anymore after today if we're at final trial, right? You will. So, we need to be on the same page. You need to make sure that whatever goals the client has, that your attorney and your team have created a clear view for that client about where you're going and how you're getting closer to accomplish those goals. I never view things as win or lose, but the ultimate question is the client happy? Because it's really all that matters, right? And prepping with your client helps them understand that you are literally doing everything that you can, so that, if something doesn't go your way in court, at least they know, okay, well, at least we weren't unprepared. My attorney did everything that she could to help me, and so did her paralegal, right? Preparing the client for cross is kind of hard, right? Because we obviously don't know what the other attorney is going to ask exactly, but we can tell a lot from their pleadings. And so this goes back to number one, where reviewing and pleadings from opposing counsel is so important. You can tell a lot from people's pleadings, right? You can tell a lot from their discovery, and you can tell where they're going to go on final and what questions they're going to ask your client. And so it's important to prepare them, give them that disclaimer I said just a minute ago, like, look, this isn't me asking you these questions. This is going to be what opposing counsel is going to cost. Knowing your exposure, assessing it, and preparing your client for things that they're going to hear on the stand, because you're real nice to your client, but opposing counsel's not going to be. That's not their job, and you shouldn't expect that ever. So, and then exhibit review, super, super important. The predicates manual I spoke about a few minutes ago, that's great. If you know that you're going to be admitting Our Family Wizard messages, you're going to be admitting photos, you're going to be admitting medical records, you're going to be trying to prove up attorney's fees on final, go ahead and access that predicates manual and just pull those predicates and have them in your attorney's trial notebook binder. I know those predicates by heart. Michael certainly does, but sometimes I literally get a little bit nervous, and I know that my paralegal or my legal assistant or the law clerk's right there, that if I start stumbling through the foundation questions to lay that predicate, it's right there and I have it. And if I need to look at it, I can. If your attorney gets a objection, lack of foundation, you've got that predicate right there. They can hand it, they can redo it, or they can say, nope, judge, I actually did the foundation correctly because my paralegal, who's a rock star, has the predicate for me right here. It's straight from the predicates manual. And that objection will definitely get overruled and you'll move on. Michael likes Michael relies on his paralegal a lot in regards to exhibit review and exhibit prep. Do you have anything to add on that, Michael?
Well, I think, obviously it goes without saying those things are important. But what I like to do, because discussing with your paralegal, either whether you're doing it with a client or discussing this case outside the purview of the client, it's important that you know the client's goals, the client's concerns, what our great evidence is, what is the not so great evidence, so that when the attorney who's handling the case comes to you, it's almost as if you're litigating the case right alongside the lawyer, which ultimately, if it's my choice, that's what I would want. Like, to have a partner to share in the litigation with me. Every lawyer is different. I'm sure your lawyers are all different than me, but I find that that's what works best. And I can tell you from personal experience that clients appreciate when the paralegal has as much information about the case as their lawyer does, because that's just another individual for them to lean on, to be able to ask questions. And so when you're discussing goals and themes with your client, it makes you a part of the case. And for me, I think that's important.
I totally agree. And your attorney will appreciate you knowing just as much about the case as they do as well. And that's another thing that will help you be indispensable at work. And it's really important for job security and just for your own confidence that, your client wants to talk to you, because they know that not only are you just as accessible or more accessible than the lawyer, but you know everything about their case. So that's super important for making your client happy, which is really all that matters at the end of the day. And sometimes, I said this morning, I was in a meeting and I said, sometimes people just like to be listened to and they like to be heard. And your attorney probably doesn't have a lot of time to do that. And I'm not saying that you guys do. I know y'all are all incredibly busy, but sometimes it is a little easier for you guys to lend an ear to them than it is for your attorney who's down in court duking it out with somebody else. All right, any questions? And feel free to
add something. Regardless of what area of law you're in, I think empathy is important, but with boundaries. Like Sarah said, the clients, a lot of times they just want to hear somebody's voice. And if that's your voice and you know what's going on in the case, or even if you don't know the latest, a lot of times that's all they need.
All right. Yeah, feel free to unmute yourselves, guys, with any questions and just jump right in, okay? All right, so moving on. We've touched on this a little bit. Number 3 mistake to help your attorney avoid is failure to identify requests for relief. You can assist your attorney by identifying client goals that we just talked about, planning a roadmap for the court, which is your summary of requested relief that we just spoke about, and ensuring that those exhibits help to accomplish client goals and pave the roadmap. What I do, I'm the intern coordinator at my job. And so kind of what I do here as like a learning exercise to get our law clerks involved, to get their brains geared up in the right way, like helping us get ready towards final trial or temporary orders or whatever hearing that we're going to have, is I have a summary of requested relief that we're going to enter with the court. And if you'd like a copy of mine, it's very simple. It literally just has the style of the case up at the top, our petitioner or respondent's requested relief, our stance on that, whether the court should grant it or not. If it's yours, obviously you're going to want it granted. If there are competing motions or competing requests for relief in their petition or counter petition, you're going to want to have one for theirs as well that says deny, 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 obviously. And then a spot for the judge's ruling on the far right. And I can give you guys a copy of that. I have a blank one and it's really simple, but a lot of jurisdictions, like I said, are requiring it now. Some aren't. The ones that aren't, that's your chance to capitalize on that. The fact that the other lawyer, like Michael said, they come shockingly ill prepared. And so that's your chance to give the court your version and your side of the story and what you want, and that's what they see first, right? And so what I'll do is, in addition to that, we'll start with one, but mine will have, instead of where the court's ruling is going to be, it'll say exhibits, and I'll hand that to an intern or a law clerk or a paralegal, and I'll say, let's do some doc review, let's go through our discovery, and let's see what exhibits will best match up to this roadmap that we're going to provide the court. Let's go ahead and pre-mark those exhibits. Let's match them up to our direct questions, our cross questions. And it gets everyone on the same page with what evidence is going to help our client accomplish their goals, and what evidence will be best to make a very clear roadmap to the judge, where the judge is more likely to grant that requested relief, right? So that is super, super important. Again, if you really want a template like that, I'll be happy to provide it for you. I have given Miss Taylor a PDF copy of this PowerPoint slide. My email is on the very first slide. Feel free to email it, and I'll email you right back with that request, that summary of requested relief. Okay. Michael, what do you like to do with your requests for relief? Do you do them very often? And in Bexar County, fun fact, they're not required here. I do them, but do you have any tips?
No, anything that your team can do to help a judge get to a decision easier is going to help your client.
Mm-hmm. Okay. Number 4 mistake to avoid, or to help your attorney avoid rather, is failures concerning attorney's fees. Attorney's fees are not costs, they are not damages. There have been some kind of rather serious overhauls regarding proving up attorney's fees. I'm blanking on the case right now. Your attorney definitely knows it, but the predicates manual that
The Rormus case.
Rormus. And that's a case that if you are not already familiar with it, you should be. And if your attorney is not familiar with it, they really need to be. That case has some really, really pivotal information on how you can get your clients' attorney's fees awarded to them. We practice family law. I'm sure a lot of you guys work for attorneys who do personal injury. In personal injury cases, you guys work on contingency fees. Obviously, in family law cases, it's incredibly unethical to charge contingency fees. We can't. And so lots of times you have a client that got drugged to court on something frivolous or a silly modification, or they got drugged to court on a totally merit-based claim, but they don't have a lot of money to fight that, right? And so it's important that if you are entitled to attorney's fees, that you help your attorney do everything they can to prove those fees up properly so the court awards them to you. And then the lodestar method, of course, it's a case that's talked about in the Rormus case. There's I think 5 elements to it. You should know those and make sure that your attorney knows them. But one of the most important things that you can help do is obviously redacting those bills. I have never personally been accused of over redacting your bills, but it is really, really, really important that you are not accidentally leaving out anything that could waive the attorney-client privilege. Lots of times, I'm not sure what billing softwares you use. My billing software is like my diary, that poor software. I bang out on my keyboard, telephone conference with client regarding blah, 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 blah. And it is 3 or 4 lines long because I want my client at the end of the month to know exactly what I did on their case, right? So they know that when they get a bill for $6,000 and there's all these phone calls, they can say, oh, you know what? Yeah, that was a 37-minute phone call where I literally let Sarah have it. Okay. And they can see what we talked about. But opposing counsel does not need to see what you guys talked about. So it's really, really, really important that, you redact within reason. You don't ever want to get your attorney accused of overly redacting bills. But in my opinion, you really have got to redact a lot. If your attorney is like me and you guys believe in giving super detailed time slip bills to your clients. Sometimes when you're preparing for a huge trial, attorney's fees are the last thing on your attorney's mind. They are too busy getting certified copies of pleadings, getting the transcripts, getting their medical records affidavits done, getting the business records affidavits done, getting exhibits in order, putting trial binders together, prepping witnesses, worrying about voir dire, and they're not worried about attorney's fees. But that's something that you can keep in the back of your mind, keeping those bills redacted, keeping them ready, printing out 3 copies of each, and getting ready to help your attorney prove them up with that predicate using ROR-MOVES and the Lodestar method. Do you have anything to add, Michael? I think we've got some questions in the chat. I'm going to look here. Oh,
Yeah,
yeah.
I don't have the citation, but I did give the case name. Just
Go
a
ahead.
couple other things. You do want to have redacted bills, but you also want to have unredacted bills in the event that the judge wants to review your billing in camera, because
Right.
in the ROR-MOVES case, the court actually talks about over redaction, and if you can't tell what was done, then the trial court shouldn't be able to then say that work was reasonable and necessary. And so this case requires a lot of work in the area of attorney's fees. So, what I like to do is have redacted billing. I like to have an attorney's fee spreadsheet, which sets out what I did and what each person did in the case. Like if you have a paralegal or an assistant, when they did it. And so that you have a summary for the court, and then also have unredacted billing for in-camera review. I will tell you, as a family lawyer, I see attorneys all the time who just stand up and testify about their attorney's fees. Under the ROR-MOVES case, that's not sufficient. However, judges, I have on one occasion, I've had at least one judge award attorney's fees with that kind of evidence. And so, it's kind of all over. You never know what a judge is going to do, right? So, what I would tell you is just be prepared. Make sure that your attorney is prepared to put on the evidence that's required by the law for attorney's fees.
All right. Okay. So our next mistake that you can help your attorney avoid, and this one super critical, failure to pursue hearsay objections in court. In family law cases and in all types of litigation, we're obviously going to have witnesses. We're going to be eliciting testimony. And I'm not sure if anyone saw the Johnny Depp trial, but if Johnny Depp can get down the hearsay rules, you can too. It's really important for you to know them. Hearsay is something that is not super intuitive. You spend a lot of time in evidence class talking about hearsay in law school, probably like the majority of the semester. But if you can get just these couple down, which I think are the most important, it's super important to understand. So obviously the rule against hearsay, it's a lot more than, oh, well, Bobby said that, that when said on the stand is sometimes not necessarily hearsay. There are exemptions and exceptions. Exemptions meaning this sounds like hearsay, but it's not. Exceptions meaning this is hearsay, but we're going to let it in because of some really interesting public policy reason. Okay. Hearsay obviously is a out of court statement made for the truth of the matter asserted. So sometimes there will be exceptions, and the most commonly used ones are present, like our state of mind, that's just how they were feeling at that moment. Excited utterance, when someone witnessed a car crash and they said, oh my God, that car hit that other car. Present sense impression. Distinguish witness availability. So when there are witnesses that are unavailable, and you can be unavailable for more reasons than just actually not being present. Someone can be like seriously ill, someone can be dead. Those types of witness availability that are in Rule 803 and in Rule 804, you need to know whether you have a witness that's available or unavailable, because some of the exceptions apply only to when someone is unavailable. So like a transcript, for example, we can have someone read from transcript, and I can admit the transcript as evidence, you know, if that person's unavailable. But if they're available there to testify, well, then I can't use that. So that's super important, because you don't want to have this really good piece of evidence and you get to court and you can't use it because the other attorney says, Judge, my client's available. He's not unavailable. They can only use that if they're available. Otherwise, it's hearsay. Prior statements or statements made against interest. So obviously, if I'm getting divorced and my husband said something to me once that is a party opponent statement or a prior statement made against his interest. So those are obviously going to go ahead and be admitted. And those are not going to be hearsay statements. But I have a really good cheat sheet that I used when I was in law school. I take it with me everywhere. I cling to it like a life preserver. And it's nice, it's short, it's small, it's laminated, and it's there on my left-hand side. And when somebody says something that I think sounds like hearsay, I can look and I can say, objection, that's hearsay, Judge. And I have my exceptions there ready if someone lodges a hearsay objection against testimony that I'm eliciting from a witness on the stand. But you can have that with you too. And I would be so happy and so impressed if someone was going on and on and on and on, and I had my paralegal here on my right side with her cheat sheet, and she said, oh, you know what, that's hearsay and it is not covered by any of these exceptions. And I can stand up proudly and confidently and say, objection, hearsay, Your Honor. And that cheat sheet helped the paralegal, it helped me, and it helped the client. So, and I can provide you guys with that cheat sheet as well. It's very good. It saved me a time or two. Do you have anything to add, Michael?
No.
Great. All right. This is something that happened to me the other day. And, you know, and I had actually failed myself to counsel my client. I didn't think that I needed to. She'd been to court multiple times, and I'm like the third lawyer on the case. And so I thought, you know, well, surely she knows how to behave in court. She doesn't. So never, ever, ever assume that your client knows that they need to behave in court. So without further ado, the sixth mistake that you can really, really be a rock star at helping your attorney avoid is failed demeanor. Remind your attorney that the judge and jurors, if you're at a jury trial, are always watching. These people love people watching, and the people they're watching are you, your attorney, and your client. So it's super, super, super important to not make faces. You know, we're not being cute, we're being professional. Remind your client that, you know, this is not funny. This is nothing to be crass about. This is not Judge Judy. We're not on the Dr. Phil show. This is not your time to have your 15 minutes of fame and shout something heinous across the courtroom to your ex or soon to be ex. And, you know, the judge is watching. And I was in the middle of an argument, and the other day, really about 2 weeks ago, and I had the judge literally start pointing and screaming at my client, telling her, there is nothing funny about this. Wipe that smirk off your face. And I was standing up, you know, making my arguments. I'm in the zone. I'm focused. And it was just me and my client that day. And I had failed ultimately to tell her, hey, the judge is watching. Don't do anything stupid. And so now the judge hates her more than they already did. So that was awesome. But that's something that you can really help do. And it's
Let me interject here. I want to stop Sarah for a second. Sarah didn't fail at anything. At the end of the day, we only have so much control over these people. You know, we want to do the best that we can for them, obviously. But, you know, you also can't, as my father would say, you can lead a horse to water, but you can't make him drink. And so, you know, I have talked to clients until I'm blue in the face about what their demeanor and behavior needs to be like in the courtroom, and they don't listen.
right.
So, you know, if you make sure that you do it, then you've done what you need to do. You've done your job. But at the end of the day, you cannot control ultimately what these people do.
For sure. But, and you know, what you can do as a paralegal is you can, you know, I'm up there worried about my argument, trying to get my point across in an efficient manner where I don't lose the judge's attention, trying to get my point across so that we can get the relief that we have requested in our pleadings, right? So I'm not looking at my client who's sitting down here next to me, but you might be sitting right next to the client at counsel table. And, you know, you can monitor your client because she's sitting right next to you, and you can tap her on the knee and say, hey man, knock that off, not cool, you know? So, but thank you, Michael, for making me feel better. All right, if we don't have any questions, I'm kind of trying to monitor the chat and it doesn't look like we have any questions yet. Okay, but again, feel free to jump in if you do have a question. Number 7, this is important and you can do it accidentally sometimes. We've all been there, but don't prove the other side's case. And the way that you can help your attorney to not prove the other side's case is to keep your attorney focused on situational awareness and your topics that we're here to get our client what they need to meet our goals today. Don't drink the client Kool-Aid either. I'm guilty of it. Just about every attorney I know has done it at least a couple times. Sometimes your clients will come to you with their hair on fire and they're going to tell you a whole bunch of stuff. And it's really important as a paralegal to delve in and kind of try and independently verify those facts so that you don't go to court and make a statement. And then for the very first time, you get what actually happened from the other side, right? So your attorneys tell you kind of, your clients will tell you kind of what they think that you want to hear. In my legal ethics class in law school, our professor played us an old clip from a black and white movie that kind of illustrated this conundrum really of, do you tell the client what the law is first and then let them tell you the story? Or do you let them tell you the story first and then you tell them the facts? Or you let them tell you the story first and then you tell them the law, right? Because sometimes if we tell them what the law is and, you know, the standard that they need to get what they want, they're going to morph those facts and mold them into a narrative that helps them. And that's your attorney's job, right? To help get the client what their goals are. So what you need is the straight up facts from the client, the good, bad, the ugly, and make sure that you're not proving the other side's case, but that you're really examining and assessing the risk and exposure that your client has before you get to final trial so that there are no surprises. Anything to add, Michael?
You know, I had a trial on Monday. It was a custody modification, and neither parent was that bad. You know, nobody was doing drugs. There was no violence. They just didn't really like each other. And it was a modification. I represented mom, 2 teenage girls. Mom, before hiring a lawyer, before the case was ever filed, just decided to up and move halfway across the state. And, you know, I sat with her, I met with her on 3 different occasions to prepare for trial. And I was very clear with her that, you know, given the circumstances, I didn't think we'd be very successful. Because my experience is when a parent just ups and leaves and then tries to get primary custody, it's usually not great unless the other parent has some sort of glaring issues. You know, I tried to keep my client focused, but during her direct examination, she basically just admitted to everything. And so that's an example of sometimes where you just can't help yourself because the facts just aren't on your side. But when the facts are on your side, you know, there's always going to be something where the other side hasn't proved their case, or you don't think they have, or they haven't proved an element of something. And you don't want to do that for them. And you want to make sure your client understands that they don't do that for them.
Well said. I completely agree. All right. We'll move on if there are no questions. This one is super important. I I'm in court pretty often for young lawyer. I have not actually been to final trial yet. But I have helped out with final trials around the office, and we have one next month actually that is going to be kind of like, one of the partners said it was going to be her biggest trial probably in her entire career, and we're getting ready on that. And you know, a little like off topic quickly, these things, sometimes we're preparing to go to trial for months and months and months and months and months, and it's easy to forget things, and it's easy to let things fall by the wayside. And this kind of goes back to what we were talking about before we got into our list, constantly being aware of where we are in cases. And I know that probably some of you work with really high volume attorneys, and it's hard to keep up with what's going on in every one of them. But there are about 2 paralegals on that case, and one of them, I can ask her any random question, and off the top of her head, she knows. And I had to come up with a timeline for that case the other day. The timeline was 3 pages long, single spaced. And she knows every pleading, when it was filed, who filed it, and she knows everything that's going on. So it's really helpful when there are so many attorneys working on the case, just to keep that in mind. But our number 8 mistake to help your attorney avoid is to make sure that we get rulings on objections on the record. Always ask for a record. Sometimes your attorney may be on autopilot at a smaller hearing, like a hearing on temporary orders or a hearing on an enforcement action, and they may not, and the judge sometimes may forget to ask. I've literally been in situations where the judge forgot to ask me if I wanted a record. And because she forgot to ask me, I didn't say, hey, judge, yes, I would love a record. And then we didn't get a record. So don't ever let that happen. But rulings on the record are important, because when you are going back and you're reviewing the transcript and trying to figure out, you know, what we can use at final trial or what we can use on appeal, when those objections are not made on the record and there's not a ruling on the record, that kind of muddies things up for appeal. If you do get a ruling that your client is not happy with and your client does want to appeal it, it creates problems. I talk about this all the time. The practice of law, the study of law, you're constantly putting the cart ahead of the horse. And sometimes the cart is not just ahead of the horse, the cart is 12 miles in front of the horse. And so you kind of constantly have to be thinking about appeal, preserving your case for appeal, preserving the record for appeal, preserving those objections for appeal. So it's really, really, really important, because if you forget those things and you're not thinking about appeal, while you're also thinking about the 87 other things you'd be thinking about at final trial, when your client does decide to appeal it, well, guess what? Now we have a whole nother slew of problems, because we weren't constantly contemplating what's going to happen if our client wants to appeal this decision. So you want to ensure that you have all available information ready for your attorney in the event the judge does not let evidence in. And you need to be really, really, really listening closely for when opposing counsel lodges an objection, your attorney gives their argument as to why that objection should be overruled. If the judge does not make a ruling on the record, you need to remind your attorney to politely and respectfully remind the judge, if I may, can we get a ruling on that objection, so that it's on the record and we've got it, right? Because sometimes they might say something like, move along, that's enough, counselor, calm down, counselor. But none of those, move along is not a ruling, right? There's objection, there's overruled, and there's sustained. Move along, that's enough, okay, no more, those are not rulings. So, you know, and sometimes judges, they've had enough after a 6-hour-long bench trial that day, and they've had enough of the mudslinging, and they may forget or just be too tired, frankly, to get that ruling on the record of overruled or sustained. So make sure that you have your bases covered on that, you're paying attention, and you're ready to tap your attorney on the knee or write a note on a legal pad and give that to your attorney, and have them ready to make sure that you get that ruling on the record. Michael, do you want to talk a little bit about offers of proof and bills of exception?
Well, just to add that if your evidence doesn't get in, there's a couple, those are two different ways to get them in. So even if your attorney comes back to the office after a trial or a hearing and says, dang it, I should have been able to get that information in, and the judge wouldn't let me. Well, there's a way to do that. It's through a bill of exception. My experience in doing offers of proof is the judges will literally walk off the bench and out of the courtroom while you give your offering because they don't want to hear it. You know, those are the two correct ways to do it. But speaking of moving along, Sarah.
All right, we'll keep it going. All right, so this is the 9th mistake that you can help your attorney avoid when you're marching down the road to final trial. Evidence needs to match your discovery responses. If you have not produced it in discovery, you cannot use it. And it sounds super elementary and super rudimentary that, you know, oh, well, obviously we all know that, right? But sometimes the 30-day deadline can sneak up on us rather quickly. And if you haven't produced it, you can't use it. That's called trial by ambush. We don't permit that. So you can assist your attorney in timely amending and supplementing all discovery responses. If your interrogatory answers have changed, amend them, supplement them. If you have more billing statements, if your client has more bank statements, if you've got more pay stubs, if they got a new job and, you know, they get paid less now, you're definitely going to want to supplement that stuff. So you can assist your attorney in making sure that all of that gets amended or supplemented prior to the 30-day deadline or the end of discovery period if you're under level 1. You know, and that goes for not just ROGs and production. That's, you know, if your answers to admissions have changed, if you have decided that you want to add some more witnesses, you got to make sure those are in your Rule 194 required disclosures. You really, really, really have got to make sure that that stuff gets done. And of course, if you have a discovery control order in place, you need to make sure that you are also comporting with those deadlines. The Texas Rules of Civil Procedure allow for us to amend any discovery deadline as long as it's done by agreement or by the order of the court or the court's own motion. So if that 30-day prior to trial deadline has been moved back or forward or extended, you need to make sure that you have that calendared. Calendaring, super important. Not enough to put on your attorney's calendar or your calendar for that matter, that, oh, today's the 30-day deadline. When I get a notification that says it's your 30-day deadline is today on my iPhone from Outlook, I know that it's not actually my 30-day deadline because I calendar my 30-day deadline on the 35th day. And I act like the 35th day is the 30th day. So I try like hell to get it done by 5. And guess what? If you don't get it done by 5, that's okay because we're actually 35 days out. So you want to make sure that, you know, if your attorney doesn't appreciate getting heart attack scares like that, then definitely, you know, calendar 35 days out, 40 days out, 45 days out, so that they know, you know, we're inching closer. And so, you know, too, because, you know, I know that there are some paralegals that their only job is to amend, supplement, and get discovery out. So if you are one of those paralegals, this is all probably old news to you, but just make sure that you're helping your attorney make sure that their evidence matches the discovery responses. You can also assist your attorney in ensuring that all exhibits are bait stamped. If there are things that need to be redacted, that they're redacted, like social security numbers or driver's license numbers, full numbers, go ahead and redact those. Credit card numbers, redact those. And then be really familiar with the opposing party's discovery responses so you can alert your attorney if they have failed to provide some piece of evidence, okay? You know, again, like I'm talking about the trial that we have next month, this trial has been going on so long that when it started, I was a second-year law student. And so, you know, lots of things that may have been produced 2 years ago, they're planning on introducing as evidence next month, might be things that I haven't seen in a really long time. And it might be things that the paralegals haven't seen in a really long time. So it's important to review their discovery responses so that when you see something and you say, man, that doesn't look familiar, you know, and you've done doc review. And so you know that that was something that they didn't amend or that they amended it because it's not what you have, right? What I like to do and what's super time consuming, but if you're a paralegal and you can get this done, if you're not already doing it, it is the way to make sure that you are the world's best paralegal. Your boss will never let you go. They're going to be super thankful is a discovery index where you have every single thing that has ever been produced to you, and not like first requests for, not responses to first requests for production, not responses to second set of written interrogatories to petitioner. I'm talking about, okay, this is Wells Fargo bank account 1234 for billing cycle July to August 2023. That's Bates stamped as blah, blah, blah. We got it on this day and it was produced in this set. And so, you know, I've been there as a law clerk where you're sitting in court and they say, okay, did they produce that? What Bates number is that? And you can flip and you say, oh, that's Bates number ABC 1, 2, 3, 4, 5, 6, 7. It's very, very time consuming, especially if you're working with an opposing counsel that is a document dumping meanie. You know, when you get 4, 5, 6, 700 documents all at one time in Dropbox, I know that you're like, oh my God, how can I index all of this? But if you take the time to do it, it is worth everything to your attorney, to you. It's going to help you whenever you're doing motions to compel. It's so great. Every time someone says, hey, can you draft a motion to compel for me really quick, Sarah? When I say, okay, well, is the discovery index updated? And when I get a thumbs up from the paralegal that it is, it makes drafting that motion to compel so easy, makes preparing for it so easy. And so that's easy. That's less work time that you spend at the office. That's less time your attorney has to spend at the office. And that's less time that that your team has to start prepping that's less time for your team to have to prep to get ready for that hearing on that motion to compel. And also to make sure that everything that they're admitting at trial is there in your discovery index. And I also have a sample discovery index. If anyone wants a copy, I can send you a blank one. They look really similar to pleading indexes, but they're a little bit more complex as far as the information that goes into them, but super easy to use. I encourage you to use them. I think we've got some stuff in the chat. No, just kidding. Okay. So, do you have anything to add, Michael?
No, I don't. I think you covered the super important stuff.
Okay, great. And all right, so now our number 10 is not the conclusion to the PowerPoint. This conclusion refers to your conclusion of trial. We're getting ready to have those closing arguments. We're getting ready for the judge to take it all under advisement or go ahead and give us a ruling on the record. And so this one is not so much as a mistake, but it would be a mistake to not consider these things when the end is near. So when you are getting ready to rest your case or to submit that last piece of evidence, put on your last witness, and getting ready to give your closing argument, it's really important to plan ahead, to stay organized, and to think about these make or break decisions. Are we going to offer this last piece of evidence? Are we going to ask this question? Is this question, the proverbial question too far, that's going to do more harm than good? Would a redirect here do more harm than good? Do we need to keep going back and forth on this witness? Are there any pieces of evidence that we have not yet admitted that we need to admit? And through which witness can we get that admitted right now before we rest our case, or before we have nothing further, and before we give our closing arguments? And so those are just decisions, and a lot of those you can plan out ahead of time, but a lot of those aren't. You know, I think the saying is that, you know, tell God your plans and see what happens, you know, like planning is a fool's errand, but sometimes it really will help. It will really help staying even keeled, organized, and ease some anxiety for you, your attorney, and your client to go ahead and start thinking about what those make or break decisions may be. And you probably already know what they are. You've got this piece of evidence that, if the husband admits to doing this, well, then you'd want to give this to impeach him. But if he doesn't say this, this could probably do more harm than good. So if he doesn't say that, and we're not going to use this to impeach him, well, then we probably need to leave this in the trial notebook, and it probably doesn't need to see the light of day in this courtroom. So just thinking about those make or break decisions when you're getting close to the end of trial can help you stay organized, and planning ahead can help you stay organized as well when the end is near. Michael, do you have any concluding remarks?
No, I want to thank everybody for their time. I know we're a little over today, so appreciate everybody hanging out and listening to us chat.
All right. Do you guys have any questions? I don't think so. Yes, and I'm looking, Lois, I will provide those indexes for you to see. And the PowerPoint, I have downloaded this PowerPoint in an Adobe PDF document, and Miss Taylor has that if she wants to disseminate it to you guys. I don't have an issue with that at all. And if you want, I'll go back up to the top. This is my email here, scasas@hhzlaw.com. If you guys want to take it down. Oh no, my email's not on here. Well, you know what? We'll add it. It is scasas@hhzlaw.com. And y'all take that down. And if you email me, I will respond today. And if you would like a copy of any of the things that I talked about today, or if you have any questions, feel free, just email me at this email address and I'll respond with a copy of whatever you need, okay?
Okay. All right. And Sarah, you can email me those forms and I can help facilitate that as well.
Perfect. I sure
Okay.
will.
All right.
Absolutely.
Okay. Thank you so much for the presentation. That was wonderful.
Great.
Yeah. Reminder of a lot of things that, yes, we have to do during trial.
Yep.
Okay, everyone, I have put the passcode in the chat room. Today's passcode is the word relief. If you would like to receive CLE credit for this presentation, please email that word and along with the request for the CLE certificate to me, Elena Taylor. So my email is etaylor@foxrothschild.com. And Ms. Casas will also send me the forms and I will send that to you. And if you would like a copy of her PowerPoint, please let me know and I will send that to you as well. Does anyone have any questions? Feel free to unmute and ask Mr. Ireland or Ms. Casas directly.
Thanks, guys.
I would just like to say thanks again to both of you guys. That was so much valuable information.
I'm glad. Happy to do it.
Thank you. Glad to hang out and share it with
Yeah.
Yes, that's pretty cool. Let's see. All right, awesome. As stated, if you have any questions whatsoever, feel free to unmute. Again, thank you so much for joining us today.
I'll make sure I get you that spreadsheet and the
Okay.
summary of request, please.
Okay. Yeah, I said the discovery index, summary of relief, and I think that's what I wrote down and then spreadsheet.
For sure.
Okay.
Elaine? Elaine?
Yes. Hi. Hi, Dana.
Hey,
How are
I just
you?
want to say thank you.
Oh, no. Thank you so much for helping us with this. Helping get this set
You're
up.
welcome.
That was
Just
awesome.
wanted to thank DAPA for reaching out to SAPA and stuff. So
Thank you
No
so
problem.
much. We really appreciate these. And if you have something else in your pocket, we would love to have you put it on.
Yes.
oh yeah, not a problem. We were just talking about our topics and stuff like that for paralegal day and stuff, and we came back with a lot of topics. when we were over at NALA for the conference.
Mhm.
Oh, perfect.
Okay,
So-
look forward to it.
Oh yeah. So they had some good topics on things to cover, and especially also for the certified paralegal exam
Okay.
for city guys and stuff like that.
Oh, that would be a great topic.
Oh,
Yeah. Yeah, they were talking about that. They gave out some of the, I gotta wait for the other stuff to come down recorded. So
Mhm.
I think Melody was there.
Yes.
Okay.
So since she's a full-fledged attendee, once the recordings come down, I want to say it's in September or October,
Mhm.
she will be able to share that with the members
Oh,
Okay.
nice.
because
Okay.
they actually have the recorded sessions
Okay.
of a lot of the CLE that they did there, and some of the I want to say majority of the certified paralegal prep sessions
Mm-hmm.
that y'all can show to y'all's members
Okay.
All right, good to know.
and share the documents and stuff.
Okay.
I
All
will
right, good to know.
watch for that. Being an
Yes.
education VP, that's one of the things that I share with my section chairs. Like for the upcoming year, or as we finish
Yeah.
out this year for options for those individuals to provide what they presented. So yeah, it's a good lead and good resource.
Yes,
Yeah,
very much.
I'm getting ready. I need to find someone who can do a notary update. And I'm thinking I may be getting an ambassador from PD, but they're coming up with the new rules, especially regarding criminal charges.
Mhm. Okay.
So we
So
want to
like,
make sure
I'm
that
a-
everyone is up to date.
Okay, I'm a notary too, so I would love to partner with you on that for that
Yeah.
information.
Yes,
Yeah,
same.
because the thing is, it's not just the traditional notary, but it's also your e-notaries. So we just
Yeah,
need to
the
make
digital
sure that
ones.
everyone is following the rules and stuff like that, so that way no one can come back to them. And
I'm gonna
you
put
know,
my
trying to
email
keep everybody safe and not get any criminal charges here.
Oh, yeah, because I constantly, have to remind people that, a notary doesn't have the privilege to do a lot of other things.
Yeah,
Especially if you're a paralegal and you're a notary, it's different than just a standard notary. You do have other things that your license, will allow you to do. But I have
right.
seen a lot of notaries try to draft documents and a whole lot of stuff.
Mhm.
And that stuff can get you in trouble.
Yes.
I'm gonna
Yes.
put my email address in
Okay.
the chat, and please reach out to me with that because I would love to do that because I know
Yeah.
some coming down the pipe.
And what I'll do is, let me see, I'll send it out to everyone. Because mine will get forwarded to my personal, but I will just put it in here because it's president@saparalegal.org.
Mhm.
And so yeah, so y'all just let me know, and then I will see what I can come up with regarding the notary stuff and get with y'all.